a big stink came from the Bay Area last night when we got word that the jury in the murder trial for the death of Kate Steinle came back with a not guilty verdict against Jose Inez Garcia Zarate, a case that got obviously national attention. It became wrapped up in the presidential campaign and really forced the issue of sanctuary city policies for the entire country to have to wrestle with. And in addition to that story, we got a couple of other doozies. A court case that basically says Prop 47 undoes a California law on car theft that allows a vehicle valued at less than $950. If someone steals it, it's just a misdemeanor. Let's talk about all of these things and possibly more with the president of the Association of L.A. Deputy District Attorneys. It's a pleasure to welcome back to the show, Michele Hanisee. Michele, good morning. How are you?
I'm great. How are you guys? Good morning.
We're fine.
Morning.
Thank you for coming on with us. We always appreciate your time and your insights into this kind of stuff. Let's start, if you don't mind, with the Kate Steinle verdict. I wasn't in the courtroom, and I'm always reluctant to jump on a bandwagon on court cases when I didn't see the trial. But with that said, it seems to me remarkable that this jury didn't go for even manslaughter, given what we've been told about the facts in the case.
I'm in the same position you are, Doug. I'm always extremely reluctant to form any opinion based solely on what I hear in the news, because we hear a few second clip about a trial that took potentially days or weeks or months. The jury sat there all day and listened to everything all day, so it's really hard to know what happened unless you were right there in that courtroom.
We do know. Let me ask you this just tactically. The prosecutors in San Francisco went for murder one. But the physical evidence, and apparently there was no arguing over this, the gun that Jose Inez Garcia Zarate found under the bench, the bullet ricocheted 12 feet in front of him and then flew 78 feet and hit Kate Steinle. It's hard to imagine that that's a deliberate attempt to murder Kate Steinle if the bullet hits the ground and ricochets to hit her. Now, with that said, you certainly could make an argument that it's second-degree murder, or manslaughter, certainly. But the prosecution went for murder one and constructed a theory, we are told, that he was looking for someone to shoot, and that this was a deliberate act, and the jury didn't buy it. But I don't know how you go. Would it have been? Can that prejudice a jury? I guess that's what I'm asking is, if you overstate the case as a prosecutor and the jury doesn't buy it, can that start the dominoes toppling to lead to a not guilty verdict?
Well, it could potentially, yes. And first-degree murder requires the prosecution to prove the murder was willful, deliberate, and premeditated, assuming that's the theory of first degree they're going on. A second-degree murder would be an automatic lesser offense that the court would instruct on, but that leaves the question of whether the court would instruct on manslaughter and whether this jury in particular was so instructed if neither of the parties specifically requested those instructions, which would leave the jury with little choice.
Yeah, it's just shocking in the extreme because everything that we've known about this. Now, again, this jury was not hearing evidence of Jose Inez Garcia Zarate being in the country illegally, having been deported 5 times. It was pretty common knowledge. It's hard to imagine that they didn't know what his background was, but that was not allowed as part of the case. The case was being tried simply on the evidence of the actual killing, how even based if you buy my argument that the jury was turned off by the overcharging of and the pressing for first degree murder, the judge apparently gave them the option of second degree and manslaughter, and they still said not guilty.
I know it's baffling, and I don't have the answers for you. I'm sorry to say, unless you were sitting there in the courtroom, it's hard to know what happened, and sometimes even then, it's hard to know what happened. Sometimes juries come to verdicts that are inconsistent with the evidence, and unless they wait outside in the hallway to tell you why, You'll never know as a prosecutor.
How does the decision get made to go for a first-degree murder conviction in the strategy session? Because this case, because it was trapped in it involves Donald Trump, because Trump, when he was candidate, Trump made a big deal about this and the whole controversial issue. And it's San Francisco, which openly boasts its sanctuary policies, and actually at one point was literally advertising it on bus benches and ads on the sides of city buses. So it's inescapable that there's a political component to this. But the city of San Francisco, the prosecutor's office, was going for the maximum charge possible. The jury didn't buy it. So how much would the surrounding politics of this factor into how a case is presented?
Well, obviously, it's going to be very, very difficult to find jurors who were completely unaware of any of the underlying facts of the situation. And a lot of times when a case is a high-profile case, if there's so much media that it's going to infect your potential jury pool in a county, you'll move the case to a different county. But in this case, there's no other place to move it unless you put it outside the U.S., which is not an option. So how do you find jurors who aren't already sort of infected with all of the media storm that surrounded this case? And I don't think it's very easy to do.
We're talking about Michele Hanisee, who is the president of the Association of L.A. Deputy District Attorneys, LAADDA.com. Let's switch gears to this amazing story, the L.A. Times reporting. A person convicted of a felony for stealing a car may have that conviction reduced to a misdemeanor if the vehicle was worth no more than $950, according to California Supreme Court. This goes back to a case involving a guy named Timothy Wayne Page, was convicted of violating a law that makes taking driving a vehicle without the owner's consent a felony. But the court ruled under Prop 47, because the car might have been worth less than $950, which is the magic line for a felony now, it's a misdemeanor. There was a time in this country when we used to hang horse thieves. If you stole a man's horse, you were stealing his ability to make a living and to survive in the Old West. And, I look at this and think, you talk about class warfare. You're basically telling somebody in the lower income brackets who are driving a car that is still maybe their vehicle and their lifeline to employment and childcare, et cetera, that if your car gets stolen, it's no big deal.
Well, it does. And as so often happens, liberal law enforcement policies most adversely affect the lower income communities that can least afford to absorb the impact. And that's the tragedy of it. There's another huge irony of this case, though. The Page case, you can violate this law either by stealing a car with intent to keep it forever, or by temporarily and unlawfully borrowing the car, or by driving the car and someone, let's say, stole it and say, here's a car I stole. I'm going to give it to you now. Go ahead and drive it. Under this ruling, the guy that stole the car is now committing a misdemeanor. The person who borrows the car unlawfully, or the person who drives the car after it's gifted to them by the truth thief, those are still felonies.
It's the more experience we have with Prop 47, and I assume 57 only compounds the problem, the bigger the disaster this is. And I don't know how much longer it's going to take before Californians realize that we have to undo the damage that was done with these two dreadful ballot measures.
Well, I hope that they're going to realize it soon, because there is a ballot initiative that's been filed with the Attorney General that would undo some of the harms of these propositions in a number of ways. And one of those things that it would do is it would start classifying repeat theft offenders, serial theft offenders, as felonies again.
We've seen since these things passed, for instance, an absolute explosion of property crime, because we pretty much told the country that if you're a thief, this is the place, this is the golden state for thieves, because we're going to not prosecute. You can steal $949 worth of property and it's a misdemeanor, and we know that with prison overcrowding, it's going to get pled down from there. First-time offender, what are the chances of any kind of time whatsoever? So it's an invitation for people to grab packages off of people's front doorsteps or to go into a CVS pharmacy and help themselves.
Oh, it's more than that. You can walk into Best Buy or Sears or any big package store every single day of the week. Walk out with a big flat screen TV, as long as it's under $950, and any of the TVs that you could carry, that's the price they cost, $600-700. You can do that every day of the week. And every day of the week, it's still going to be a misdemeanor, no matter how many times you do it. And every time that happens, you are at most going to get a citation to appear. You're not going to get arrested if you're stopped or caught at all. And then if you go to court, if you bother to go to court and get sentenced, even if you get a half a year in jail, you're not going to do any jail time. Right now in LA County Jail, if you get sentenced to 180 days in jail, you are going to walk right out the door the first day.
Yeah, we had that report. We talked about that a week or so ago. So I just want to make this clear. If I decide to go on a crime spree, and my employers would argue I already have, but that's a different story. But if I were to go on a crime spree and go into one of the big box stores and swipe a TV that's worth, let's say, $800, and then the next day did it again, and the next day did it again, and did it every day for a month, and I had them stacked in my home, and they finally caught me, the aggregate of all those stolen televisions doesn't count. The only thing that counts is that I stole an item that's only worth $800, and therefore it's a misdemeanor.
That is correct. But
That's
one
insane.
of the things this initiative would fix, and I really want to point that out. It would allow the aggregation of repeated thefts over repeated days exactly like that. That is one of the benefits of this initiative. It's called the Reducing Crime and Keeping California Safe initiative.
Oh, that's completely insane. I mean, we need to pass this like today because it's just crazy. I mean, it's really crazy.
It is. Before we got to pass it, we need to collect signatures to get it on the ballot. So when the citizens see those signature collectors out at Costco or at the market, look for this one. It's called Reducing Crime and Keeping California Safe initiative, and this is the one that will help stop these repeat criminals.
All right. Well, we, by all means, will continue to cover that story. Thank you so much for coming on with us, Michele. We always appreciate it.
My pleasure. Have a great day.
Okay, you too. LAADDA.com, the Association of LA Deputy District Attorneys, Michele Hanisee. That's just